if the father of my child is filing in court and filing claims against me that I feed our child fast food and our child didn't go to the dentist and he has a list of concerns and he's filing for custody, what will the judge do?
All right. So first, the quick disclaimers for the Q&A session. Billy and I don't become your lawyer by doing the Q&A. Our answers are just legal information. We can't give you specific legal advice. We'd have to sit down and like really get into your full situation. And this is based on Arizona law because we're both licensed in Arizona. With that said, I mean, the fact that he filed the petition is something you're going to have to deal with. And I'd be going through each allegation and starting to build a defense. And even if some of the allegations are true, but they're not good, I would be making changes. But, you know, you kind of have to look at, well, what's good or bad? Like, is the judge going to change parenting time based on how much McDonald's is consumed? Like, I've never seen a parenting time order based on McDonald's. So I would have a really hard time seeing any judge base a parenting decision on fast food. What were some of the other allegations? Dentist?
Go to the dentist.
Yeah, I mean, relevant. If you missed one dentist appointment though, you know, happens. If the kid's never been to the dentist and has some dental issues, again, I would be looking to solve that.
Yeah.
But again, is the judge going to bring the hammer down because there, you know, some things fell through the cracks on the dental work? It really depends on the situation, but likely no, if that's the only thing. And a lot of these things that are coming up are stuff that the court is going to say, parents, you need to communicate and figure this out.
It really doesn't matter how much fast food you feed your child. It does matter if your child is extremely unhealthy and has health problems and you're unwilling to do anything to help them in their health problems. You're not following a doctor's recommendations. Your child is suffering. You know, what if your child has, let's say your child has type 1 diabetes and you're feeding them sugar and you're not monitoring their insulin levels? That matters. It doesn't matter how much fast food your child is eating in and of itself. And with regards to the dentist, if you are not taking care of your child's needs, if they have an infection in their tooth that needs to be taken care of and you're not, I think that matters. If you miss some appointments, I don't think that matters at all. If it's not impacting your child's health, go to the dentist. That's the other thing. A quick and easy way to handle that is just to go to the dentist. And then if that issue is resolved, it's resolved. So these are the types of claims. I love these examples because this is kind of exactly what we're talking about. You kind of put on your lawyer hat and think about, what is the judge looking for? A change in circumstance and best interest of the child. So is the fast food and the dentist thing a change in circumstance or not? If it's not, you might be able to get rid of it with a motion to dismiss. And then best interest. If your child is thriving, then these things don't matter to me. If your child is not thriving, if your child is struggling, then the accusations, I think, have a lot more weight or could have more weight. And you may want to take some proactive measures to get out in front of that issue. Have you had that come up before?
As far as just minor things all being thrown into petition or? I mean, yes, I have. Recently, a mom just ran to the court and filed some papers saying she was upset about a schooling issue. And the court ended up just summarily denying it on its own because it wasn't done correctly. But, you know, I think that the person who wrote in the question, if dad is really just, you know, being unreasonable and really trying to just cause problems for whatever motivation he has, I would be trying to set dad up as a vexatious litigant, you know, somebody who is not, you know, following what the court wants, which is first talking to the other parent and trying to resolve stuff, but just running to the court. And so I would be trying to really get some language and some final orders, really attacking dad for his tactics if possible. Because what another thing that I've found is if there starts to be an order or two within a history of a case, because, family law cases can go on for a long time, that has really adverse findings against a parent, it can be really hard to overcome those, even if you have a
True.
new judge,
I
even if
agree with you.
circumstances have changed.
Yes.
So even if things look really bad and the other side's attacking you, if this stuff isn't true and you're able to show that and get some final orders that are saying, oh, dad is an unreasonable litigant and things like that, that could be beneficial down the road as well.
Yeah, that's a great point. A great point. Next question. How do you get your husband to sign a settlement offer? He's put it off for 2 weeks. Trial was extended. He verbally agreed to sign. He's continued to relapse on drugs. He's finally in treatment. And I know his sobriety is the #1 top priority, but I've been waiting and I just want to move forward. What can I say to nudge him without angering him or overwhelming him? He'd often tell me not to control him. Should his lawyer nudge him more than I? And then she also followed up, I have a protective order, but I'm still trying to be polite. He and his attorney continue to state that me being polite during minimized communication about the children means I'm not scared of him and the protective order should be dismissed. How do I manage the boundary? There's a lot to that question.
Yeah, and it's kind of hard to answer. Like if I had been involved in this case from the get-go, I'd probably be like, okay, let's try this tactic and let's try that, because I would know the players a lot better. So again, this is just information. Like I don't know all of these players and I don't know what would be the best tactic, but I would definitely be going through his lawyer and saying, hey, look, if you're not going to sign this by this date, I'm going to have to call the court. I'm going to have to file a motion with the court asking the court to set another hearing and enforce, if there was an order for him to sign, to enforce that order. And then also maybe talk to the lawyer about coordinating. If the guy's in treatment, see about getting the papers there. They usually have, a notary on staff. I don't know. They usually have some stuff that makes it so that everything can be done right there. And I would be looking at that angle too. I think you need to be a little cognizant of as well of where he's at on his sobriety deal, because you don't want him to come back later and be like, I was under duress and I didn't know. And so pushing too much at this exact time could be problematic. And you may just want to let a little more time pass and see what happens with him with his sobriety. On the flip side, if you think he's going to be out of this sober house and he's going to be back using again, then maybe this is the time when you need to really push to get the signature. So it's hard for me to analyze this without really knowing, without being a part of the situation. Any thoughts, Billy?
I mean, I agree. Trial's been put off. There's purportedly an agreement. I don't know what that agreement is. I don't know if that agreement is super favorable to you or not, especially given the alcohol or drug issues. Like, it's very difficult for us to answer that. But I do want to talk for a minute about the second part, about a protective order. So if you have a protective order against your ex, how should someone be communicating?
Well, if he has a lawyer, you can communicate through his lawyer. And so that's what I would do. There's also an exception in the protective orders for communications about legal stuff. You can really get the specific language in there. So there is an exception for, going to court and doing legal stuff and getting a signature on a decree may fit within that provision. But again, if he has a lawyer, I would be going through the lawyer. And then if the lawyer is giving you a runaround, I'd be going to the judge and be like, Judge, this is what happened when I went to the lawyer and this needs to be done. Like, we reached an agreement. Getting the judge involved may be a very useful tactic in this situation, because the judge wants the case closed too.
The judge absolutely wants to sign your agreement most of the time. The other thing I'm reading between the lines here is sometimes when you've had addict as a spouse, you can be in a very codependent relationship.
Mhm.
You can feel very responsible for their sobriety, for their feelings, for their wellness, for their level of functioning. And I'm not saying this is you, but I'm reading that this could be an issue where you're feeling like you have to be a support for him, and that supportiveness as politeness is coming across as you don't actually need a protective order. You're this person's friend. So I think that can be a very tough situation. You don't have to prove you're in fear to keep a protective order in place. They now last for 2 years. So that's been extended. So now if you get a protective order, it's in place for 2 years. If you want to get it extended, it's generally hard to do without a new incident of violence. Whatever happens during those 2 years, if there's pages and pages of text messages between the two of you and you want to extend it after the 2 years, and they use those text messages to say, like, this is unnecessary, that might be evidence that it's unnecessary.
One thing I want to add is I'm putting together the order protection course. It's almost ready.
Right.
So that'll get added to the members area soon. And it goes through just the start to finish overview of how to get an order of protection, how to contest one, what happens if there's mutual orders filed. So there's a lot of different information, and that's going to be available to the members shortly. So I know orders protection come up quite a bit, and the court continually tries to streamline the process and make it easier, and they've done a really good job, but there's still some nuances, and there's trial aspect to it as well if a hearing is requested. And
Yeah, and
it's a full trial. I mean, it can be short, but all the same trial procedures apply.
Well, and they have their own rules of evidence. They have their own rules of procedure, and they have their own rules of evidence. So I'm so glad that we've got a designated course on orders of protection available in the members area. The members area is now open, which is super exciting. And what do people get when they join the members area?
So, right now we're getting ready to launch the classes in January. So this is just the early bird access to start getting your feet wet with some trial skills, with some of these mini courses we're going to be putting in there on various different issues. And then there's also other free resources, or not free resources, but resources within the members area that cover various aspects of divorce and custody. And that'll all be leading up to the classes starting on January 9th. So Mondays, we'll be talking about divorce. Tuesdays will be about custody. And then Wednesdays will be about modifying or enforcing a custody order or a divorce decree. And then on Thursdays, we'll be talking about trial skills and practicing them. So each day has a lecture component, but then also the Q&A to get your questions answered. And that'll be a 10-week course starting in January.
That's so exciting. It's very, very exciting. And if you're interested, but you're kind of unsure, I think we have the first 2 lessons available on Modern Law's YouTube page. And the trial skills course is 10 different lessons, all really, really good if you are headed into court and you need to figure out how to represent yourself. Really, really good information. Let's see, a couple other questions here. My ex didn't show up for mediation and compared the error of our holiday time to the same for the error that he shouldn't have to pay child support. Okay, so what I'm reading is maybe mom took dad's holiday time and dad didn't pay child support. And then he didn't show up for mediation. I don't know if your mediation is required before you do an enforcement action. Maybe that's what we're talking about. I don't know. There's not a lot of information there.
So, right, if the court ordered him to attend the mediation, there could be some repercussions from the court. Nothing too serious, but they might, give him a little slap on the wrist. If he has a reason for missing it, something he got COVID or, something like that and couldn't go, the court may reschedule it. So
Mhm.
even if you think he's lying about the reason, the court may be like, okay, I'll take that, go back to mediation, because the court just wants you to try mediation. So it's possible it could get rescheduled. There is no direct connection in the law between exercising parenting time and paying child support. Child support is due regardless of what happens with parenting time. So he can't just decide not to pay. And if this case is through the clearinghouse, that non-payment will be recorded and interest is going to accrue, and they could take his tax return and pay you that way. I mean, there's some different options, but one of the biggest things here, I mean, if he was through the clearinghouse, he wouldn't be able to just say, I'm not paying. And that's kind of the point, is if you can get your case so that child support is through the clearinghouse and the payer is an employee and their wages are being garnished, it's a system that goes forward regardless of what's happening between you and your co-parent. So I would be looking to get that child support order through the clearinghouse so that he can't use it as a means to punish you if you guys reach a disagreement on parenting time.
Mm-hmm. Yeah, she did give us some more information. He didn't give a reason. The court says they will charge him $100, and I can try to remodify child support. Okay, another question I've got here is about expert witnesses and the process and the benefits of hiring one for a high conflict case.
Yeah, when you have a trial, if you've got dad testifying and mom testifying and that's it can be really tough for the judge to make a decision because your evidence may be somewhat equal, and it's just a real toss up between who the judge decides to believe or whose proposal the judge decides to adopt, or maybe the judge does something in the middle. And that's where an expert witness can really help to change that dynamic. And instead of it being a he said, she said, now you have an outside third party who can come in and give an opinion that can actually make things, much more persuasive. But you really need to figure out, okay, what am I using the expert for? What kind of report is going to be generated? What's going to be in there? What are they going to testify to? Is the other side going to get a counter expert? Are we going to have a battle of the experts? And kind of if this is maybe something about a child, what's happening to the child along the way? So a lot to consider, and experts can be pricey too. So there's a lot to consider with getting an expert involved. What are your thoughts, Billy?
And I love expert witnesses. I do. I just generally think that they can be incredibly useful because judges obviously have their own biases, their own inclinations, their own framework that they see the world through. They have a lot of discretion. So especially if you're going in front of a judge, let's say you're going in front of a judge who always gives equal parenting time. That's what they do. That's their belief. And you believe that in your case, it would not be in your child's best interest to have equal parenting time for your particular child. In that case, I would think that it would be very useful to have an expert say why your child would not be served well with equal parenting time, because the judge has to consider the evidence. Now, that does not mean that the judge has to agree with your expert, but they have to consider the evidence, and that would help you or could help you. It's hard though, because judges largely, because they have so much discretion, can do whatever they'd like.
Yeah, I mean, if you're looking at expert witnesses, you're probably working with a lawyer. So, keep working with your lawyer on that issue.
Let's see. Another question we've got is, let's discuss legal decision-making with final say.
Yeah, there was some case law on that within the last few years. And the question was, if we have this designation of joint legal decision making with one parent having final say, aren't we just awarding sole decision making? And if memory serves, the court said, no, you could do it that way and it still is joint.
Yes.
I have a hard time with my clients selling the final. I mean, obviously, the parent that wants it, you know, you don't need to sell anything to them. But for the other parent, I have a really hard time getting that agreement into place. Generally, we'll just end up saying joint, and really, I like to break it down. You know, people think of decision making as covering everything, but it
Right.
doesn't. It's
No.
education, it's healthcare, it's religion, it's personal care decisions. So I'm really looking, okay, where's the dispute here? Is it
Right.
education? Is it healthcare? Is it religion? Very rarely is it religion these days.
Mhm.
And then personal care is so nebulous like that. That usually doesn't come up. So it's either education or healthcare is where the rub is. And then that's where we're looking to get some really clear language on just those issues that are in dispute. And it may or may not involve mom or dad being a final decision maker.
Yes. Yeah. I think when you have children with ongoing medical or educational needs that are unique or just not, if you anything other than a very healthy, very average, very well-adjusted child. If your child currently takes any medication or sees any specialists or is on the autism spectrum or whatnot, and there's high conflict, I like to build a parenting plan that reduces deadlock, because joint legal decision making can create deadlock, and deadlock seems to favor the inaction versus action. So if my client, usually it's moms who have taken point on therapy and decision making, and if there's a high conflict divorce and dad now wants, the hard part about this dynamic is mom's used to making this decision. She just wants to make the decisions. Dad had previously given her this authority. She feels like she's the most qualified. She just wants to make the decisions. And now dad's like, but it's different now. We're divorced. I get to weigh in. And he's right. But I like to figure out ways to reduce deadlock, which might mean I put into the parenting plan that the parents are going to continue to use the healthcare providers they've got and follow any recommendations for the future, or something like that. Or decisions like they're going to continue with XYZ treatments and X school, and won't make any changes unless blah, blah, blah. So really trying to get in front of major decisions like you're talking about, I think is a good thing. The other thing is, if you have parents in different states, I think it's a good idea for the parent who's driving the kid to school every day and watching the kid in school every day to have the final say. Let's say the parent moves within where they're at. Like, I feel like letting the out-of-state parent block that decision could be a problem. So I really try to think about what's going on in each individual case when negotiating and crafting the right parenting plan.
Yeah, definitely.
The other thing that comes up is counseling. One parent wants to get a kid counseling and the other parent refuses. How do you handle that?
So I definitely want to get the refusal in writing, because if we are going to go to court, I want to be able to show the judge that this parent is objecting to getting the child help. I'd also like to try to get some reasons why, if any. And possibly open up to a family counseling. Say, look, if you have some concerns, why don't we set up a family session and see if everybody can get involved? Have the other person have some say on what counselor gets selected. That is a bit of a slippery slope. So you've got to analyze the situation to see if you want to open that door or not. Those are some of the things. But it can be tough. And usually the objection is that they think the counselor is going to turn the kid against them somehow or something like that. And, in practice, the counselors generally don't come to court. I've seen a counselor to come to court here and there, but it's very rare. There's the counseling records. And sometimes they're helpful. Sometimes they're totally vague. Sometimes they're not correct. So in practice, yes, the counseling can be very valuable, especially if the counselor reaches a conclusion that one of the parents is not safe. The counselors are mandatory reporters. They would need to call DCS. But yeah, sometimes you have to get a court order to order counseling if the other side just absolutely refuses.
Yeah. And if the reason you think you need final say is because of that, which happens, somebody might say, I need final say because I need to get my kids in counseling. The other thing that you could do is write into your parenting plan that either parent can take the kid to counseling. So there's some ways you can get around this final decision-making issue by building in what you need immediately. So we are out of time for today. How do people register and become members?
All right, visit winwithoutlawschool.com and the information's there. If you have any questions, you can email info@winwithoutlawschool.com. And we look forward to teaching you how to have success in the courtroom without a lawyer.
Great to see you, Julie. Talk to you soon.
Bye.